Assalamualaikum warahmatullahi ta'ala wabarakatuh. Hello everyone. I hope that all of you are in good health and in good spirit. Okay, we will today, alright, continue with our lecture on law of agency. Alright, there are few parts that we will cover that are formation of agency, how agency is formulated, duties of agent, duties of principal, and termination of agency. This is what we covered under the law of agency. Okay, formation of agency, section 135 of Contract Act provides that agent is defined as a person employed to do any act for another or to present another in dealings with a third person. Okay, so principal is the person to whom the act is done, who is so represented, and the agency is the relationship which subsists between a principal and an agent. You see, principal, okay, and then appoint a person to be an agent or appoint employee, right? This relationship we call as agency, the principal and the agent or employee, right? For this agent or the employee to deal on behalf with a third party on behalf of the principal. So this is agency and the formation of agency. There are 5 ways where how we can create agency. Okay, there are 5 ways. We will go one by one, but now I'll just share with you the 5 ways. First, by express appointment. Okay, the person expressly clearly appoint another to be his agent. Second, by implied appointment, right? Number 3, by ratification of by the principal. And number 4, by necessity. Yes, agency can be formed by necessity. Okay. Number 5 is through the doctrine of estoppel or holding out. Okay, you want to know what is estoppel or holding out? You have to wait until we go for the explanation. Okay, now we go for the first explanation. Number 1, by express appointment. You see, expressly appoint, clearly appoint. I don't know who they are. I just took it from internet. The copyright belongs to them. Right? Either in written or in oral form. A person appoint another to be the agent. So, section 140 of Contract Act mentioned that express appointment can be done either in written or in oral form. Alright? So now we have an example. I'll share with you an example here. Airline companies. You see airline companies? They have allowed travel agency to act as their agent to sell the air travel pursuant to the provisions set forth in general agreement. Basically, the travel agent, they are the agent. We call it travel agent, right? They are the agent for the airline to sell the tickets, right? This is express appointment. What does it mean by implied appointment? How does it happen? So, we will refer to section 140. I paste here so you can see, because I'm not sure whether you are looking at your Contract Act or no. So I paste here for you to have a look. An authority is said to be expressed when it is given by words spoken or written. Okay. If you say it orally or you put it into writing, this is what called as express appointment. Okay. An authority is said to be implied when it is to be inferred from the circumstances. So, implied appointment is through inferred from circumstances, right? and things spoken or written or the ordinary course of dealing may be accounted circumstances of the case. Okay. This is the definition of express and implied authority. So, by implied appointment, right? The law may infer the creation of an agency by implication when a person by his words or conduct holds another person as having authority to act for him. Okay, I'll give you some, let's go for illustration. What does it mean? Alright, infer the creation of agency by implication when a person by his words or conduct hold another person having authority, which means A hold B as having authority. Or what does it mean? So we refer to illustration. Now, A owns a shop in Kajang. He lives in Kuala Lumpur. So A appoint B to manage his shop. So A tell B, manage my shop, right? So B is the one who deal with all the ordinary course of business in A shop. So B purchased good from C. They are selling something that, of course, when you sell something, you need to purchase something to sell, isn't it? So let's say they have this hardware company. So B need to purchase all the materials. B are purchasing from C. So in purchasing the materials, right, B use A's name. B also use A's fund. Alright. A knows that B are using his name in purchasing the material for the shop. Right. A also knows that B is using his fund to purchase the material for the shop. Okay. So A knowledge. Okay. By A's action knowing this. Okay. B has the implied authority from A. Okay, even though A didn't say, B, you have the authority to purchase, you have the authority to use my name, you have the authority to use my fund, A did not say that clearly. But when B did everything, B used his name, B used A's name, B used A's fund, A knows about it, A just keep quiet, A did not say, B, stop using this, okay? A acknowledge whatever B's done. Say, basically, A is giving B authority impliedly. Okay? So, impliedly. Okay, so now, see the third party, knowing that he is dealing with, from C's perspective, C is dealing with A. Okay? C is the third party who's selling goods to B. Okay, basically, C knows that B is the agent of A because B used A's name, B used A's fund. So while selling, even though he's the third party, he sells goods to B. He knows that B is the agent of A. Even though A never go to C and say, "See, B is my agent." No, I never do this. We do it impliedly by the action of B and A acknowledge. It become implied appointment. From the perspective of C, B is the agent of A. Okay. Appointment of agency through or by ratification. What does it mean by ratification? When the principal basically ratify the act of the person, another person, as the act of his agent, or whatever act done by his agent which is exceed the agent, the principal authority, right? But the principal ratify. So this is agency by ratification. We go here. Look at this, right? Agency by ratification, it can be either from two situations, as I said earlier. Okay, now, agent was appointed. A appointed B. B is A agent. However, A told B, you can make dealing but not more than 100,000 ringgit. However, B made some dealing exceed 100,000 ringgit. Okay, so exceed his authority. Number one, agent who was duly appointed has exceed his authority. Right. So we call this first situation, right? Second situation, a person who has no authority to act for the principal has acted as if he has the authority. Okay. Person has no authority at all right? But he acted as if he is the agent, all right? So there are two situations now. In both situations, okay, the principal can either reject or accept, right? So in both situations, remember this, the principal can either reject or accept. Okay. This is provided under section 149 of your Contract Act. Okay. When the principal accept and confirm such contract entered by the agent who exceeded the authority or entered by a person who acted as if he is the agent, right? The acceptance is called ratification. Okay, so ratification can be expressed or implied. This is provided under section 150. So we go for the first situation. Okay, the agent exceeded authority. The principal can accept or reject. If the agent exceeded authority, the agent has no authority anymore. The agent is not an agent anymore. Okay. Ali asked Abu to purchase house for 50k only. So Abu is the agent of Ali. Ali is the principal. Okay. Now Abu purchased house 70,000. That is exceed the authority. When he exceeded the authority, he is not the agent of the principal anymore. Alright. That's why the principal under section 149, the law give the principal chance whether the principal want to reject or want to accept. If the principal reject, then all the costs must be borne by the agent. There are no more agency and principal if the principal reject. If the principal accept, section 150 say principal can accept, imply or express. Okay, so if the principal accept, right, this is what we call as agency through ratification. Why? Because the principal actually ratify the act of the agent. So in the first situation, I refer back, okay, the principal can accept or reject. If the principal accept, it become agency by ratification. So let's see the second situation. A person, Ali acted as if he has authority to act on the other person, Abu, as his agent. So now, you see, the principal now, okay, a person, Ali acted as if he has the authority to act on the other person, Abu, as his agent. So Ali actually is acted on behalf of Abu. So Abu has the right to either accept or reject under section 149. Okay. When Abu accept and confirm Ali's act, this is called as ratification. Okay. And as I said, ratification can be expressed or implied. Agency also may be formed by necessity. So what does it mean by necessity? Can we go to this example first? All right. I think it's easy for you to understand if we go for example first. So in this case, in these examples, yeah, X sent some horses to Y through a railway company. Y did not take the delivery of the horses at the destination, so it caused the railway company to feed the horses. If the railway company did not feed the horses would die, isn't it? Until Y come and take the horses. Okay, now the railway company go to court and ask for compensation for the money that they have spent in feeding the horse. Alright. So in this case, the court held that the railway company actually was the agent of necessity and could recover the amount spent on feeding the horses. Okay. For agency to be created through necessity, all right, by necessity, there are three conditions to be fulfilled. Okay. Number one, first, it is impossible for the agent to get principal's instruction. Okay, this is provided in section 142 of Companies Act. Okay, section 142 of Companies Act. It is impossible for the agent to get the principal instruction. Number two, the agent's action is necessary, all right, in order to prevent loss to the principal. So the agent must do it so that the principal would not suffer loss. Number three, the agent of necessity must have cited in good faith. All right. So the agent, when they do this, they must ensure that they do it in good faith. So if all this condition has been fulfilled, a person may be the agent of necessity. Okay, of the principal. All right. So this is how agency by necessity is created. Okay, by estoppel. First of all, we have to understand what does it mean by this estoppel, right? Basically, estoppel is a principle which precludes a person from asserting something in contrary to what is implied by a previous action or statement of that person, alright, or by a previous pertinent judicial determination. Okay, how do we understand that? What is that basically? What does it mean? Okay, we refer to the definition again, alright? It stops someone from saying contrary to what has been implied by a previous action, by his previous action. Okay. So the best way to understand this is to go to the example, right? Didi tell Fifi in the presence of Gugu that he is Fifi agent. Okay. Okay, in front of Gugu, Didi said, I'm your agent, isn't it? You like me to be your agent, right? And I'm the best agent of yours, for example. Okay. Fifi did not deny, and she kept quiet, right? She did not deny, and then he just kept quiet. Later on, Gugu entered into contract with Didi, right? Believing that Didi is the agent of Fifi, right? Now, Fifi cannot tell Gugu that, look, this person is not my agent, okay, right? She cannot do that. Now she is bound by the contract, even though there is no agency existed in actual between both of them, right? This is what it means by estoppel, right? So you see, let's go to the notes here. A person cannot be bound by a contract made on his behalf without his authority. Is it correct? A person cannot be bound by a contract made on his behalf without his authority. Yes, it is correct. Right? Nobody shall be bound by a contract made on his behalf when he never entered the contract and he never give permission. Right? However, if he by his words or conduct allow a third party to believe that a particular person is his agent, even though that particular person is not, okay, and the third party relies on it to the detriment of the third party, he will be stopped from denying the existence of that person's authority to act on his behalf. So that's why you refer to the example here. Okay? If he, by his word and conduct, allow third party to believe, in this case, right? Fifi allow Gugu to believe that Didi is her agent, isn't it? because she never denied. So allow third party to believe that a particular person is his agent, even though actually in the actual world, okay, Didi is not Fifi's agent, okay, and the third party relies on it. So now Gugu rely on that. Gugu believe that they have relationship, agency relationship, and enter into contract. So enter into contract. He will be stopped from denying the existence of that person authority to act on his behalf. So now he is stopped. Okay. In our example now, right? Fifi is stopped from saying Didi is not her agent. So I hope you understand what does it mean by estoppel now. Please do drop your question in our WhatsApp group or Putra Blast. Duties of agent. Section 164 to 169 of Contract Acts provides for duties of agent. Okay. So we summarize into 4 here. Okay. Agents must conduct the business according to the direction given by the principal. Alright. Whatever the direction given, the agent must follow. In doing his job, the agent must actually do with skills and diligence. Right? They cannot just do it negligently. It's not allowed. It must be with skill and diligence. And agent also, they must render proper account to his principal on demand. So whenever the principal asks for the account, the agent must give it to the principal. Okay. And it is agent's duty to communicate with the principal. It is duty to communicate with the principal. Agent cannot just simply keep quiet, never update the principal of the business of or whatever job they do. You see? So they have to communicate. And we have number 5 and number 6, right? You see, in agency, if an agent use, right, whatever power rendered to him or her, okay, to get benefit for her own good, okay, for example, Didi use the agency to have personal gain, okay, she must actually do this with the principal consent. If she do this without the principal consent, she has to give whatever benefit that she get to the principal. So now Didi and Fifi, let's say they have agency. Didi is the agent of Fifi. So Didi use this agency to have personal gain without the consent of Fifi. Alright, now Fifi got to know. Didi has to render whatever benefit that she got to Fifi as the principal. Okay, because she did not get consent. Unless Didi from the very beginning tell Fifi, I want to do this to get some personal gain, whatever, and Fifi did not has any issue. So that is okay. Without consent, whatever personal benefit gain must be given to the principal. That is number 5. Okay, now we have number 6 here. You see, principal and agent has this fiduciary relationship, right? What does it mean by fiduciary relationships? Basically, it means the relationship of trust. Both of them, they created relationship of trust. So basically, the agent also is the trustee for the principal. Okay, agent act for the principal. Okay. That's why agent cannot basically get personal interest. Okay. And agent cannot have a business similar with the principal. Okay. And compete with the principal or have conflict interest with the principal business. Agent cannot do that. It's not allowed because they have fiduciary relationship. They have the relationship of trust. So agent must not allow his personal interest to have conflict with the interest of the principal. This is the main point, alright? Agent cannot let her personal interest to be in conflict with the interest of the principal. That's why I said if the principal has boutique, agent is doing business with the principal of boutique, right? Agent cannot go and incorporate another company and have a business of boutique also. So now this is they have conflict of interest now. Okay, for example, right? Now rights of agent, right? Right of an agent. 169 to 178. All right. Number one. Agents has right of retainer out of the sum received on principal account. Agent's duty to pay sum received for principal. Agent remuneration become due during the completion of the act. This is all simple, so I don't explain. Do you need explanation? Okay. Let me know, right? Agent remuneration become due during the completion of the act unless there is any agreement to the contrary. Okay, this one I explained. Once the agent have done his task, alright, grab food, the person, the rider is the agent, alright. Once he has done his task, he give you the food, you give him the payment because he have completed the act. Unless there is any other agreement, unless there is any agreement to the contrary, unless you want to pay not COD, you want to pay by transfer or payment money to the principal. Okay, you want to you want to buy McDonald's using Grab food, all right, and then the rider is the agent. You don't want to pay the agent after the rider send you food, you pay to the principal. This is unless there is any agreement to the contrary. Agent is not entitled to remuneration for business misconduct. Okay, clear. Agents lien on principal property until the amount due to himself for commission disbursement has been paid to him. Alright. He can hold a charge on the principal property until whatever principal has to pay to him, the principal paid. Right? Agent to be indemnified against consequences of lawful act. Right. Agent to be indemnified against consequences of act done in good faith. Okay, basically in these two, the agent do something, advance action to protect the principal, not to cause loss to principal. Okay, so and the act done by the agent is lawful, right? And he do it in good faith. Okay, so the principal must indemnify, okay, the agent. Compensation must be given to agent for injury caused by principal neglect. Okay, negligence must pay compensation. Not to let his interest conflict with his duty. So, right of agent, not to let his conflict, not to let his interest conflict with his duty. Duty of principal to agent mentioned in section 175 to 178, right? You see, principal to agents, okay? Duty of principal to agent. Number one, to pay the agent the commission or other remuneration agreed unless the agency relationship is gratuitous, right? Number two, not to willfully prevent or hinder the agent from earning his commission. First, you have to pay remuneration as agreed. You agreed to pay, so you pay. Number two, you don't simply stop the agent from getting his commission. Right? You promise commission and suddenly you do not want to pay commission. It cannot be done. This is the principle, duty of principal to pay the commission. Right? And then when the agent do some acts, alright, the agent spend money within the duty given by the principal. So the principal has to identify the agent. So number three here, to identify the agent for acts done in the exercise of his authority. When the agent do something within the authority, he spend his money, so the principal must identify. Okay? Right of principals. What are the rights of principals? Okay, Now, remember I said agent cannot make secret like secret profit without the consent of the principal. If the agent do that, the agent has to return everything to the principal. So now, right of principal. It is the right of the principal to benefit gain by agent when agent deals on his own account in business of agency without the principal consent. So, it is the principal right to get the money gain by the agent who do some other business using the agency for the agent benefit. So, all this benefit become the principal rights. So, it's the principal right to gain, to get everything, alright? Do you understand what I'm saying? Okay. Number 2, non-liability of employer of an agent to do a criminal act. If the agent do some criminal act, is not the liability within the liability of the employer. Now we have breadfruit. Remember? PKP, RMO. Everybody use riders, right? So some riders, I don't remember. One of the company, what they did, the riders, they send ketums, water, right? Which is illegal. They send some cigarettes, illegal cigarettes, right? And they are the agent of the company. So this is the rights of principal. So that action fall under this non-liability of employer of an agent to do a criminal act. Okay, you cannot implicate the employer, right? So the agent has to take their liability by himself. Termination of agency. Okay. There will be two ways of termination of agency. Number 1, the act of the parties, from the act of the parties. Number 2, by operation of law. Right. How the parties terminate the agency? You know, by creation we have few by necessity, by express appointment, by implied appointment. Now termination. Right. The act of the parties. Okay. When the agency is for indefinite duration, the agent can terminate the agency by giving reasonable notice of termination to the principal. So the agent can give reasonable notice. Okay, they don't have any definite duration, no specific time. So the agent can terminate giving reasonable notice as provided by section 159 of Contract Act. Have a look at your Contract Act, please. Number 2, where the agency is for definite or fixed period of time, the agent cannot terminate. The agent cannot simply terminate the agency before the expiry of that period without just cause. So they need a just cause, right? With that just cause only, the agent can terminate the agency for a fixed period of time. Okay? By operation of law, there are circumstances in which agency may be terminated by operation of law. Right. Number 1, when the contract of agency has been performed. So they have performed, they can discharge themselves, right? Number 2, upon the expiry of the period fixed in the contract of agency, they have fixed period. The period actually finished, expired. So the agency is terminated, right? Upon the death of the principal or the agent, too bad, yeah, by section 154 of the Companies Act, right? Number 4, when the principal or the agent becomes insane, they lost their mind, unsound mind person, right? So by unsound mind, so the court can actually terminate the agency. When the principal becomes insolvent or is made bankrupt. Okay, a bankrupt person, they cannot hold post, right? So they cannot be a partner, right? So here they cannot be. A principal become insolvent, the agency is terminated. Or, upon number 6, upon the happening of an event which render the agency unlawful. Anything that happen. Something happen, after the thing happen, the agency become unlawful. For example, we have a law. The law allows this person to have agency under this law. For example, ABC law we have, Right. And now, after 20 years, the government decided to make whatever under ABC, we want to abolish ABC law. Whatever whatever activities under ABC law is considered unlawful, for example. Okay. So the agency under this will become unlawful. The moment it becomes unlawful, the court can terminate the agency. This is the termination of agency. Okay. All right. Thank you. I do hope that you would understand, and I'm happy to receive your messages for any question in the WhatsApp group or Putra Blast. Thank you very much. Have a nice day.